Hello viewers, this is me Dr. Sanyogita, Assistant Professor, Himachal Pradesh University, Shimla. Today I am going to discuss the topic Components of Judicial Process. First of all, introduction of the topic. The judicial process refers to the methods and procedures by which courts interpret and enforce the law, resolve disputes and contribute to the evolution of legal principles. For those affected by the legal system, it encompasses a framework of laws, binding norms, procedures and institutions through which individuals can seek justice. However, judicial processes are not uniform across different countries. Each legal system adopts distinct models, assigning varying roles and powers to the courts. This variation reflects the diversity of approaches to justice worldwide. The aim of this lecture is to explore the different elements that comprise the judicial process in various legal systems. In civil law systems, laws are typically codified in comprehensive legal codes that are frequently updated. In contrast, common law systems evolve through judicial decisions, where legal principles are largely shaped by case law, and precedents hold significant weight. Civil law systems, however, give less importance to judicial precedents. Judges in these systems are generally free to make decisions without being strictly bound by previous rulings, placing greater emphasis on statutory laws. However, in India, the Constitution upholds the doctrine of binding precedents through Article 141, which mandates that decisions of the Supreme Court are binding on all lower courts. Additionally, aspects of the common law judicial process are reflected in key Indian legal codes, such as the Criminal Procedure Code, Civil Procedure Code, the Law of Evidence and various rules governing the Supreme Court and High Courts. There are two primary models of judicial processes. One is adversarial, second is inquisitorial. India primarily follows the adversarial system. In this model, the accused is presumed innocent until proven guilty by the prosecution, which must prove guilt beyond a reasonable doubt. This principle of presumption of innocence is a cornerstone of the adversarial system. The judge in such a system typically adopts a passive, non-interventionist role, overseeing the trial but not actively investigating the case. The scope of the dispute, the evidence presented and other aspects of the case are largely determined by the parties involved. Cross-examination of witnesses is a crucial tool for each party, allowing them to challenge the opposing case and uncover information that the other side may not have presented. It is a well-established principle that the primary responsibility of higher courts is adjudicatory, that is, to determine what the law is. A straightforward interpretation of the Indian Constitution reveals that the judiciary was designed to be a key institution for enforcing laws and providing authoritative rulings on legal matters. However, it was not intended to have policy-making powers. As such, powers were always seen as belonging exclusively to Parliament. Despite this, there has been considerable debate about the Indian judiciary's increasing assumption of powers that were not originally envisioned in the Constitution. The judicial process is not meant to be a tool of disruption or dissolution, and this fundamental principle has not always been consistently upheld by the higher courts. Nevertheless, the significance of the judicial process remains clear, especially considering its vital role in ensuring justice. The judicial process in India is complex and consists of various components, including first is legal reasoning, second judicial activism, third appellate jurisdiction, fourth procedural laws. Legal reasoning. Legal reasoning refers to the approach of making decisions based on sound legal principles rather than emotional impulses. Rigidly adhering to legal rules without considering their broader context can lead to decisions that lack objectivity. When judges rely solely on precedent or act with bias, they risk losing the impartiality required to render their fair judgment. Rational legal decisions must be grounded not only in the law but also in logic, reasoning, experience, and thoughtful analysis. As Thomas Fuller aptly put it, when a judge puts on his robes, he puts off his relation to any and becomes without pedigree. This underscores the idea that judges must remain neutral, devoid of personal biases or affiliations. Reasoning, in essence, is the mental process of justifying beliefs, actions, or emotions with logical arguments. In this legal context, legal reasoning involves applying laws to specific facts to arrive at just conclusions. It is a crucial aspect of the decision-making process, ensuring that judicial decisions are not only grounded in the law, but also in careful deliberation. Effective legal reasoning promotes fairness, encourages informed debate, and fosters the improvement of legal practices in future. Ethical reasoning, too, plays a vital role in shaping the decisions that influence both legal outcomes and societal standards. Justice often requires judicial creativity, where judges extend existing legal principles or even create entirely new legal categories to ensure fairness. As society evolves, new challenges and conditions emerge that affect the equality of life and equitable distribution of resources. These shifts call for legal innovation, as established laws may need reinterpretation to address contemporary issues. In this context, judicial legislation becomes necessary, not in the political sense of creating laws, but in judicial sense of adapting the law to meet new circumstances. As Sam Schuman has noted, this form of judicial action should not be confused with the role of legislative body. The core aim of judicial reasoning is to achieve justice and fairness. Judges must consider all factors relevant to making decisions that are both just and equitable. This requires more than just applying the law as it stands. Judges must be willing to extend existing laws and precedents creatively, ensuring that they align with the principles of justice and equity. In cases where the facts do not neatly match previous legal rulings, judges are expected to apply the law in a way that ensures fairness for all the parties involved. Judicial activism. Another key component of the judicial process is judicial activism. The Indian judiciary has long been seen as the protector of the Constitution, especially in safeguarding individual rights against the excesses of the state. When necessary, the courts have played an active role in defending the fundamental rights of the citizens, ensuring that these rights are not violated by unjust or arbitrary actions of the government. The term judicial activism was first coined by Arthur Schlesinger in 1947 in an article titled "The Supreme Court, 1947", published in Fortune magazine. While India made significant strides after independence, a larger segment of the population still lived below the poverty line, and justice remained largely accessible only to the wealthy. This led to the rise of judicial activism in India, allowing the judiciary to reach out to the marginalized sections of the society. The relaxation of the doctrine of locus standi opened the doors of the courts to disadvantaged groups, giving them a chance to seek justice through public interest litigation. Judicial activism, however, was not limited to PILs. It played a crucial role in promoting women's empowerment. The judiciary took significant steps to protect women from exploitation, especially in workplace. For example, in landmark case of Muhammad Ahmad Khan versus Shah Bano Begum, the Supreme Court extended the period of iddat, that is, the waiting period of Muslim women must observe after divorce, from customary 4 months and 10 days, ensuring justice for Shah Bano Begum. The judiciary has also issued numerous judgments that enhanced women's status in society and bolstered their faith in the judicial system. Judicial activism has been evident in various other areas as well, such as environmental protection, protection of the bonded laborers, protection against inhuman treatment in jail, professional ethics in medical field, child welfare, and addressing fake encounters. Different jurists have provided various definitions of the judicial activism, reflecting the wide range of issues it encompasses. Judicial review. Under Article 13, 32 and 226 of the Indian Constitution, the higher judiciary is empowered to exercise judicial review. This power allows the courts to declare any legislative, executive or administrative action void if it conflicts with the Constitution. Judicial review is considered a fundamental aspect of Indian Constitution and is essential to upholding constitutional supremacy. Judicial activism refers to the practice where judges make rulings based on their personal policy perspectives rather than strictly adhering to the letter of the law. It contrasts with the judicial restraint, where judges emphasize the principle of stare decisis, that is, respect for precedents, and avoid revisiting settled legal principles. While judicial activism can sometimes lead to broad interpretations, its primary goal remains the protection of the rule of law, ensuring the supremacy of the Constitution, and promoting justice in evolving societal contexts. Appellate jurisdiction. Appellate jurisdiction refers to the authority granted by law to a court, tribunal, or judge to adjudicate disputes or pass judgments on legal matters. It is a fundamental element of the judicial process, as it determines whether a case can be heard in a particular court, either at the initial stage or on appeal. Appellate jurisdiction in India allows a higher court to review, to amend, or overturn the decisions made by a lower court. This power is granted by the Indian Constitution, specifically under Articles 132 to 136. The higher courts, particularly the Supreme Court, have the right to re-examine the decisions of subordinate courts, providing an essential safeguard for ensuring justice and fairness in the legal system. A certificate from a competent high court is required to seek the appellate jurisdiction of the Supreme Court. The Supreme Court of India holds the position of the highest court of appeal and is entrusted with interpreting and protecting the Constitution. It has a broad and significant jurisdiction handling appeals from subordinate courts, resolving disputes between states, and safeguarding the fundamental rights of the citizens. Its role as the final arbiter in legal matters is crucial in maintaining the constitutional framework and ensuring justice is served across the country. Supreme Court's Appellate Jurisdiction, Article 132. It grants that the Supreme Court appellate jurisdiction over appeals from high courts in matter related to the Constitution. Article 133 confers the Supreme Court appellate jurisdiction over appeals from high courts concerning civil matters. Article 134 gives the Supreme Court appellate jurisdiction over criminal cases appealed from high courts. Article 135 affirms the Supreme Court's authority over matters related to the legal jurisdiction of the Federal Court. Article 136 provides the Supreme Court with the discretion to grant special leave for appeals, allowing individuals to petition the court in cases where it deems appropriate. In simpler terms, an appeal can be made to the Supreme Court against a decision from a high court, but only with the consent of the High Court or by seeking special leave from the Supreme Court itself. The Supreme Court sits at the pinnacle of India's judicial system. With an extensive range of jurisdiction, it is tasked with the upholding the rule of law, ensuring that the actions of the legislature and executive are kept in check. Historically, the Supreme Court inherited the jurisdiction of the Federal Court, and the Privy Council and Parliament has the power to extend the court's jurisdiction further. However, no legislation can limit the inherent authority of the Supreme Court. Over time, the jurisdiction of the Supreme Court has expanded, notably with the introduction of public interest litigation, which allows even marginalized sections of the society to seek justice. PIL has enabled the court to address crucial issues such as human rights, environmental protection and social justice, ensuring access to justice for the most disadvantaged. The court's epistolary jurisdiction, which allows it to entertain cases through letters or petitions, has further solidified its role as the protector of fundamental rights. Procedural laws in the judicial process. In India, laws are created by Parliament, enforced by executive and interpreted and applied by the judiciary. Laws can be divided into two primary categories: substantive laws. These are the laws enacted by the legislature establishing the rights and duties of individuals. And the second are procedural laws. These refer to the rules and processes that courts follow to hear and adjudicate cases. Substantive and procedural laws are both crucial for the legal system. Without substantive laws, procedural laws cannot exist, as they would lack a legal basis to govern. Similarly, procedural laws ensure that substantive laws are applied justly and consistently. The two types of laws complement each other and work in tandem to ensure fairness and efficiency in the judicial process. Numerous provisions within procedural laws have been designed to expedite the resolution of criminal and civil cases, making the legal process more efficient and responsive to the needs of the society. Procedural laws. Procedural law refers to the set of rules that govern the operations of the court system. It outlines how court proceedings are conducted, the methods used to protect individual rights during the legal processes, and the specific procedures that must be followed. This area of law regulates aspects such as pre-trial procedures, the presentation and admission of evidence, how witnesses are examined and cross-examined, and how judges address objections during the trials. Different legal systems have their own approaches to procedural laws, with some focusing on fairness and truth between the parties involved, while others emphasize the need for prompt dispute resolution. Additionally, some procedural laws prioritize the rigorous application of legal principles. Procedural laws serve as the framework for enforcing substantive laws, and their characteristics often reflect the nature of the substantive laws they support. Procedural laws can generally be divided into two categories: civil procedure laws and criminal procedure laws. In India, the Code of Civil Procedure 1908 is the key civil procedural law. It governs the administration of civil cases, including the enforcement of civil judgments and orders. On the other hand, criminal procedural laws govern how the criminal justice system operates, while substantive criminal laws define punishments for offences. Procedural criminal laws establish the methods and steps to apply those laws. The Criminal Procedure Code 1973, now BNNS, which has recently replaced, dictates the procedures for handling criminal cases in India. The goal of judicial proceedings is to uncover the truth using available evidence to determine the guilt or innocence of the parties involved. Both substantive and procedural laws are critical for the fair administration of justice. Substantive laws outline the rights and duties of individuals towards one another and the state, while also defining the scope and purpose of legal disputes. In contrast, procedural laws guide how cases are managed in the courts. These two branches of law are complementary. Substantive law sets the rules, while the procedural law ensures those rules are effectively applied. As the Supreme Court has affirmed in multiple rulings, procedural law is always subordinate to substantive law. Characteristics of procedural law and their implementation. Procedural laws must embody certain essential characteristics to ensure justice is served effectively and efficiently. Key among them are proper implementation of procedural laws. The proper implementation of procedural laws in India is a complex issue involving several factors such as the effectiveness of the legal framework, the efficiency of the judicial system, and the accessibility of justice for the general public. For any society to be considered civilized, the effective enforcement of laws is fundamental. This implementation is governed by principles like the rule of law and natural justice. To ensure proper implementation, several factors come into play. Legal framework. The laws must be clear and well structured, providing a solid foundation for judicial processes. Judicial efficiency. The judicial system must operate swiftly and without unnecessary delays. Thirdly, access to justice. The judicial process must be accessible to all, particularly the disadvantaged and marginalized. Legal reforms. Regular reforms must be undertaken to keep the system modern and relevant. Judicial independence. Courts must function independently without external influence to maintain fairness. One major area requiring reform is the service of summons. Delays in serving summons are a significant bottleneck in the judicial process, hindering timely justice. The introduction of various amendments to the Code of Civil Procedure has aimed to tackle this issue. Furthermore, the National Commission has urged high courts and state governments to implement additional measures such as one-time collection of process fee, combining process fee with court fee, using information and communication technology to facilitate faster services of process. The e-court mission mode project has been a key initiative in integrating technology within the judiciary. The success of this initiative shows that technology holds great promises in streamlining judicial procedures. For instance, a study on Bangalore rural courts revealed that the notice and summons stage consume about 1/4 of the duration of a civil suit. On average, courts take 273 days just to serve summons, creating unnecessary delays. The report recommends technological solutions and process re-engineering to reduce these delays and improve overall efficiency. Pre-trial hearing and case management systems in India, the concept of pre-trial hearings is not fully integrated into the judicial process as a separate and distinct feature. Although provisions within the Civil Procedure Code and Criminal Procedure Code exist that could facilitate this. Pre-trial hearings are a standard feature in countries like the UK and US and Singapore. These hearings are scheduled meetings between the litigants and their counsels, held before a judge or judicial authority to clarify and narrow down the issue in dispute. The goal is to expedite the trial by identifying the key points of contentions and managing the case efficiently. Pre-trial hearings can also play a significant role in encouraging settlements through amicable compromises between the parties involved, potentially reducing the burden on the courts and promoting quicker resolutions. Integrating such practices more consistently into the Indian judicial system could improve case management and ensure faster disposal of cases. Promoting the use of ADR mechanisms. Alternate dispute resolution refers to a range of methods that offer alternative to traditional court litigation. The Government of India has actively supported the use of ADR as a means to resolve disputes more efficiently. The legal framework for ADR is primarily provided under Section 89 of the Civil Procedure Code 1908, which recognizes 4 key methods: arbitration, conciliation, mediation and judicial settlement, including settlement through Lok Adalat. This section allows courts to refer cases to one of these methods if there is a potential for a mutually agreeable settlement between the parties involved. ADR mechanisms are increasingly favored by disputing parties due to their ability to provide faster and more cost-effective resolutions compared to traditional court proceedings. The efficiency of ADR in terms of cost and time makes it an attractive option for many. Recently, the courts have also mandated mediation as a legal requirement, reinforcing its role in dispute resolution. Judicial data and statistics. Judicial statistics plays a crucial role in shaping policy decisions both within the judiciary and by the government. Equally important is making this data publicly available to key stakeholders such as advocates, litigants, researchers and the general public. Access to such information helps to improve transparency and provides insights into the functioning of the judicial system. The successful implementation of the information and communication technology initiatives and standardized data collection practices will significantly enhance the ability to manage and track judicial processes. These innovations will lead to better categorization and monitoring of cases, reduced paperwork, more efficient time management and ability to track overall trends in case pendencies. Conclusion: incorporating the above discussed elements into the judicial process can create a more effective and efficient legal system. By promoting ADR, improving access to judicial data and adopting technological advancements, the legal framework can evolve to better meet the needs of all stakeholders involved, ultimately contributing to a more accessible and transparent judicial system. That's all for today's lecture. See you in the next lecture with new topic. Till then, thank you. Goodbye.